Computer. Peace, love, and prosperity to all of humanity on planet Earth, Midgard. Today we'll be going over the Vienna Convention on the Law of Treaties. It's a good read because it shows those Moors that are stuck with the old paradigm of individual processes that, as it relates to international law and the United Nations and the ICJ, etc., in order for you to seek remedy through those organs, it requires for you to approach them as a state, not as individuals. Also keeping in mind, like I mentioned earlier, as individuals, you may gain remedy as an individual, right? However, this is as Moors, we're a nation. So if your remedy does not cover all the other people, then we're not moving in unison. It's all our salvation is found, first of all, in number one, knowing who we are, and then number two, coming together as a unit, in unity, to make with the understanding of our divinity and culture and nationality, in order for all of our people to gain the same remedy as any other one would. But the only way that we can exercise unity to then utilize certain laws for our protections and salvation, etc., is through a state. If we say that we're a nation of people, then where is the state that represents the nation of people? You see, it's non-existent, or at least up until now. And we cannot stand on the Moroccan Empire because the Moroccan Empire is in a shallow grave. And so the establishment of our state is what's going to bring the empire back online. And so in order for us to establish our state, we first need to know who we are. Once we know who we are, we come together in unity, create the Constitution, ratify it, deposit it, and promulgate it through the United Nations. Now we have our state, which is dealing with the first box, which is sovereignty and independence, to then move on to the second phase, which is integrity of domain, that deals with all your laws, your consular court, your laws, your national trust, your nationality paperwork, your state ID, etc. Once that's accomplished and we get to a certain point, then you move on to economic liberty without any inequality. And that's going to come after we take the United States to the ICJ, because let's keep it real. They're not really just going to acquiesce to our demands just because we said so. We've been asleep too long. So now we need a third-party referee, i.e. the United Nations, to come in and assist us with the belligerence of the United States, and that's where the ICJ comes in. And the United States, when they go to the ICJ, they always lose for the most part. So they're not really interested in going to the ICJ, but they will push us all the way to that level, because Jacob is not going to stand still and allow us to take over his banking. Who is Jacob? The Jews. All right. So the Vienna Convention on the Laws of Treaties, 1969. Let me increase the font. Okay, I'm glad to see that my cursor isn't running. Okay, I'm trying to, okay, there we go. All right. Can we all see that? Can we all see these words pretty well? I don't want anyone squinting. All right. Vienna Convention on the Law of Treaties, done at Vienna on 23rd May, 1969. And by the way, before I continue the reading, now that we're recording, I want to give honors to AMPAG for the way they handled this this insurrection, this coup d'etat, this overthrow of the government, by attempting to remove Chief Judge of Consular Court J. Jermaine Bey, Justice J. Jermaine Bey, as well as the Mufti, Attorney General or Consul General Kanye Shobe. What was done was in bad taste. It was off-putting. It was a lot of slander that took place from the old wazir. But J. Bey and the competent Moors of AMPAG, they settled the matter swiftly, pretty quickly, based on the state being under a state of emergency. And when you're in a state of emergency, you cannot allow the government to remain stagnant. The show must move on by any means necessary. And so they did what they needed to do. It was a competent approach to the diplomatic approach to the insurrection, and it got settled. It's a good example for all states that are coming online. This is why AMPAG has considered themselves to be the beacons of light, because they are the leaders in this movement of international law and statehood. And so therefore it was incumbent upon them to show and prove their competency for the other states to recognize and have a reference point to how to deal with whatever belligerents that may surface within their state. So I just wanted to put that out there on the record in public for the world to understand how AMPAG may feel about the circumstances that took place with AMPAG. So with that said, let's get into the reading. Excuse me. So Vienna Convention on the Law of Treaties, done at Vienna on 23 May 1969. The states, you see, I mean, the second word is states, all uppercase letter state, right? S. The parties to the present convention. So these the current whatever states they're referring to, which is the member states of the United Nations, are parties to the present convention. But that shows you that it's all about states, not individuals. It doesn't say the individual parties. It says the states parties to the present convention. Considering the fundamental role of treaties in the history of international relations, recognizing the ever-increasing importance of treaties as a source of international law and as a means of developing peaceful cooperation among nations, whatever their constitutional and social systems. Noting that the principles of free consent and of good faith and the pacta sunt servanda rule are universally recognized. Let's not gloss over this word. Let me copy and paste it. And let's look it up. It's always important. I'm always looking up Moorish information. That's why you see these Moors up here already. All right. What is pacta, which I know what it is, but let's make the point clear. A brief, easy, quick search. Let's just look at Wikipedia. Pacta sunt servanda, Latin for agreements must be kept. So the agreements must be kept, meaning that if you're a signatory power or a contracting state of any of these treaties, the provisions that's within those treaties must be kept. The agreements of each treaty must be kept. It's a brokered. What does that mean? A brokered is a legal maxim in Latin that is in a strict sense. So it's in a strict sense derived from traditional legal authorities, even from ancient Rome. The word is a variant of the Latinized name of Burchard of Worms, Bishop of Worms, Germany, who compiled 20 volumes of ecclesiastical rules. Okay, so when you use the term pacta sunt servanda, agreements must be kept, right? It is a brokered, right? Which means in a strict sense. So agreements must be kept in a strict sense, right? Which means there's no deviation. You must adhere to the treaties. That's essentially what it's saying. No sense to read. There's no need to read the rest. Now we know what pacta sunt servanda means. So let's read this over again. Noting that the principles of free consent and of good faith and the pacta sunt servanda rule are universally recognized. So the fact that the agreements must be kept are universally recognized in the strict sense, right? Affirming that disputes concerning treaties, like other international disputes, should be settled by peaceful means and in conformity with the principles of justice and international law, recalling the determination of the peoples of the United Nations to establish conditions under which justice and respect for the obligations arising from treaties can be maintained. Having in mind the principles of international law embodied in the Charter of the United Nations, such as the principles of the equal rights and self-determination of peoples, of the sovereign equality and independence of all states, of non-interference in the domestic affairs of states. I haven't read anything dealing with individuals, of the prohibition of the threat or use of force, and universal respect for and observance of human rights and fundamental freedoms of all. So what are we talking about here? Peace, security, non-interference in the domestic affairs of state, prohibition of use of force. So use of force has been outlawed, is prohibited. Interference in the domestic affairs of states is outlawed, it's not allowed. So any question dealing with our state concerned with the United States or any other foreign entity interfering with our domestic affairs is null and void. Why? Because the Vienna Convention on on the laws of treaty said so. International law said so. The Charter of the United Nations says so. And most if not all of these states are signatory powers to these treaties. Now, even if they weren't signatory powers to the treaties, these rules still remain in force, whether you're a part of it or not. But we are, because we have acceded to these treaties. We've definitely acceded to the Vienna Convention on the laws of treaties. So that makes us obligated to what? The pacta sunt servanda rule in any other state for that matter. Okay? So it's dealing with the observance of human rights and fundamental freedoms of all, or for all, I should say. And it comes from the United Nations. I was just talking to someone the other day, and they're trying to make the point that the United Nations is evil, the United Nations is this, the United Nations is that. They asked me, have I read an article from a legitimate scholar? And I'm like, scholars are cool, but their information is not necessarily, what's the word, res judicata. If you need something that's res judicata, you deal with law. Law is what it is. It's black and white. There is no personal interpretation. It is what it is. Whereas scholars, they may utilize reference points and should I say cross-referencing other information from other scholars, and from there they draw their own conclusion to write their books or write their articles. It's still based on their own interpretation of the matter, whereas law leaves no room for your own interpretation. It is what it is. It's solid. It's res judicata. Okay, and so based on that principle, you can't tell me that the United Nations is evil, because the purpose of the United Nations is for peace, security, respect, and observance of human rights, fundamental freedoms for all, etc. Okay, let's make that point clear. Moving on, believing that the codification and progressive development of the law of treaties achieved in the present convention will promote the purposes of the United Nations set forth in the Charter, namely the maintenance of international peace and security. Did you hear what I just read? Okay, let's read that again in case you didn't hear me. Believing that the codification and progressive development of the law of treaties achieved in the present convention will promote the purposes of the United Nations set forth in the Charter, namely the maintenance of international peace and security, the development of friendly relations, and the achievement of cooperation among nations, diplomatic relations, which means that us, AMPAG, and the United States must engage in friendly relations and cooperation. Moving forward, affirming that the rules of customary international law will continue to govern questions not regulated by the provisions of the present convention. Have agreed as follows. Part 1, Introduction. Article 1, Scope of the present convention. The present convention applies to treaties between who? Individuals? No, states. States. We have been called minority or minors for quite some time now. Why do you think that is? Because we haven't grown up and or raised our degrees to understand that we're supposed to deal with matters as states, not individuals, and definitely not as subjects to the regime of the United States, begging, marching, praying for your enemy to write legislation on your behalf. Come on. Come on. Why have we been undertaking those processes when we as Moroccans have the authority and the power to enact our own legislation for our own salvation? But that's because we've been blocked from these documents, from this information, from our nationality. Instead, we've been taught that we were Moorish Americans, but we're not Americans. You see, we're Moroccans, period. America is one jurisdiction, Morocco is another. And Morocco is the dominant jurisdiction. America is in Morocco. Therefore, Morocco must govern America. However, America is governing Morocco, i.e., minorities. This is where that comes
Islam, Wazir.
Islam.
I have a point of interest.
Please do.
It brought to mind that I was speaking with a Moor 2 weeks ago in regards to what is known as a self-executing treaty. Mm-hmm. And he tried to basically convey the point that although this Moor was not a part of a state government, that he as an individual can enforce a treaty as an individual, in which that he tried to use the term a self-executing treaty to prove his point. And just to, speak on that for a second, I'm going to read just a few sentences from a few different things I briefly looked up on Google. It says, what is a self-executing? It says, what is a self-executing treaty?
Hold on, brother. Let me hold you real quick and hold that thought. Before you continue, everyone on the line, and if you don't know, this brother that's speaking is Akil Zibay, the Wazir for the newly established state called Maru State Republic. I just wanted to introduce you, good brother. Go ahead, continue.
Thank you, Mark. So it says, what is a self-executing treaty? It says, at a general level, a self-executing treaty is one that may be directly applied in the courts, whereas a non-self-executing treaty is one that requires legislative implementation before it may be applied by the courts. And another section goes to say, the question raised, what makes a provision self-executing? It says, thus a constitutional provision is self-executing if the nature and extent of the right conferred and the liability imposed are fixed by the Constitution itself. So, and that's half the answer. But basically, to just to clarify the points up for the Moors who may be watching later on, self-executing treaty, as it stated in the statement, said if the nature and extent of the right conferred, that means in the Constitution it has to be conferred, states the Constitution, the state confers the nationality. So it has to be a Moroccan state conferring a nationality, right? So being that the United States is not upholding the treaty like it should be, right? Because they they've been acting belligerent and just breaking so many things, right? Not even operating as what they're supposed to be operating as. So a self-executing treaty in their constitution, yes, they say treaties are supreme law of the land. That is correct, but it's not their job to enforce certain things if they're not even a state that's supposed to enforce that. They have their constitution for their state governments, so-called states, just as we should have, right? But the self-executing treaty, if we're not part and parcel to a Moroccan government, that's non-existent.
Islam, good brother. I'm glad you pointed that out.
I yield the floor.
Islam, good brother. Appreciate it. Thank you for pointing that out, because I have been hearing about more speaking on self-executing treaties. Why are they saying that? Because they're trying to stand on the narrative of individualism, which kills the idea of unity. Why do we want to continue operating as individuals when we can operate as a unit? Tell me one hood in America in which gangbangers gangbang as individuals. I'll wait, and I'll be waiting forever. These guys click up with a bunch of other guys to form their own gang, right? They unify amongst themselves around a gang for protection. That's the micro. On the macro level, on a more competent level, we can consider the gang as a state. Because keep in mind, the United States themselves are gangs. So how do you deal with that gang? You need your own gang. How do you establish your gang? A state under international law, which will give you the protections that you need, according to all that I read up here, the preamble. You understand?
Before you go, Islam, well said, Wazir. I just had one question for the Wazir of what's the name of the government?
Meru State
Meru.
Republic.
And that's Indiana, correct?
Formerly known as Indiana, yes.
Well, I'm not, you know. And but the question I had was, when you read that, the first thing it said was general, something about general, right? Was that general capitalized, or was this? Did they mean a general in the army or something, or was this in general meaning widely?
Islam, it wasn't capitalized. It was just general, as in the general understanding.
Okay, Islam. Thank you, good brother. Wazir. Thank you, sir.
Islam. All right, moving on. Article 2, use of terms. 1, for the purposes of the present convention. So now it's giving us a glossary, if you will. A, treaty means an international agreement concluded between who? Not individuals, but states, in written form and governed by international law, whether embodied in a single instrument or in 2 or more related instruments in whatever its particular designation. So what is a single instrument or 2 or more related instruments? The Treaty of Peace and Friendship, 1787, and the Treaty of Peace and Friendship, 1836. It's the same one, or they're the same treaties, but there's 2 of them. Well, what's the difference between the 2? Well, the difference is that on the second one, which is 1836, it tells the signatory powers, which in this case would be the United States and Morocco, that they had, after the 50-year time period. See, the first one said that the treaty would be enforced for 50 years. That's it. 1836 changed the language to it would be enforced for 50 years with a 12-month notice of dissolving. That's not the word that they use. I forgot the term. In other words, the 1836 treaty allows either the United States of America or Morocco to quit the treaty with a 12-month notice. The first one did not have the 12-month notice. So up until now, the United States exists on a month-to-month basis, meaning that we can always cancel the agreement with a 12-month notice. That's the difference between those two treaties. But it's two instruments that are related. That's what this is saying on part A of this glossary. Part B, ratification, acceptance, approval, and accession. Brother Akil, pay attention to this part, because you've already ratified your constitution and you've deposited it. But then you also got to accede to the treaties, right? So what do these four terms mean? It mean in each case, the international act so named whereby a state establishes on the international plane its consent to be bound by a treaty. So you ratify the treaty, you accept the treaty, you approve the treaty, you accede to the treaty. Okay? The prophet said, you change the language, you change the people. Jay Bay always says that we need to change our vernacular. Well, how do we do that? We start learning and understanding international law terms, such as treaty, ratification, acceptance, approval, accession. C, full powers. So, Akil, you got to download the full powers document that I was just telling you about. Full powers means a document emanating from the competent authority of a state, designating a person or persons to represent the state for negotiating, adopting, or authenticating the text of a treaty, for expressing the consent of the state to be bound by a treaty, or for accomplishing any other act with respect to a treaty. So your full powers document is giving your Minister of Foreign Affairs the authority, the delegation of authority to do what? Right here, what it says. Represent the state for negotiating. Who did that? How did that happen? That red circle. And I saw Shin Bay name on there. Shin, you doing something over there, good brother? Whatever you're doing, please stop. Somehow, for some way, somehow, for some reason, it's translating onto my document here. So it's giving the Minister of Foreign Affairs the powers to represent the state for negotiating with other foreign nationals or other foreign states, other ambassadors, plenipotentiaries, ministers of foreign affairs from other states, etc. Adopting or authenticating the text of a treaty. That's what you'll be doing with that full powers document, because you must accede to those treaties, and you need your Minister of Foreign Affairs to have the full powers to do so. For expressing the consent of the state to be bound by a treaty, or for accomplishing any other act with respect to a treaty. So this is the reason why you must download the full powers document from the model instrument section of the website, the UN website, to then give him the powers to accede to the treaties that you need to accede to, which you need to accede to basically all of them, or as many as possible, to include the treaty that we're going over now. D, reservation. Why is this red thing on there? I don't know how that happened, y'all. I apologize for that. I don't know how that happened. Reservation means a unilateral statement, however phrased or named, made by a state. Notice that we keep talking about states here. I don't know how many times you see the term state. Let's see. Control F. Let's see how many times the word state appears in this document. Let's see. Where is it? Okay. Let's see. States. Oh, my ass is not working. You see, I'm having problems with this computer. My ass is not working right now. Oh Lord. It's going out slowly but surely. I gotta replace it. Oh man, I apologize about that. States is not showing up on my yeah, I had to run a diagnosis, and it's telling me that my keyboard is going out. So I gotta replace this computer real soon. I apologize about that. I wanted to show y'all how many times the word state shows up here. Okay, anyway, let's get back to the reading. Reservation means a unilateral statement, however phrased or named, made by a state when signing, ratifying, accepting, approving, or acceding to a treaty whereby it purports to exclude or to modify the legal effect of certain provisions of the treaty in their application of that state. All right. Negotiating states means a state which took part in the drawing up and adoption of the text of the treaty. So 2 or more states sit at a round table to negotiate the terms and conditions of the treaty before they draw it up, and then they draw it up, and it becomes you ratify it, deposit it, and it becomes in full force, or it becomes enforced, the treaty. So that's what negotiating state means. F, contracting states means a state which has consented to be bound by the treaty, whether or not the treaty has entered into force. Party means, or G, party means a state which has consented to be bound by the treaty and for which the treaty is in force. H, third state means a state not a party to the treaty. Okay? And I, international organization, means an intergovernmental organization, i.e. the United States. Brother Shen, I don't know, your name is what's keep coming up. Every time this little red, I don't know what you're doing over there, good brother, but could you please?
I said I'm trying to erase it.
Oh.
I was doing that for my personal reference, but I didn't know it was going to transfer to you.
Oh yeah, it's transferring over here.
I'm working on erasing it now.
Okay. All right. 2, the provisions of paragraph 1 regarding the use of terms in the present convention are without prejudice to the use of those terms or to the meanings which may be given to them in the international law. In the internal law of any state. All right. So Article 3, international agreements not within the scope of the present convention. The fact that the present convention does not apply to international agreement concluded between states and other subjects of international law, or between such other subjects of international law, or to international agreements not in written form, shall not affect the legal force of such agreements. B, the application to them of the application to them of any of the rules set forth in the present convention to which they would be subject under international law independently of the convention. C, the application of the convention to the relations of states as between themselves under international agreements to which other subjects of international law are also parties. All right, let's go back up. So what does it say for Article 3? What's the title? International agreements not within the scope of the present convention. So there's other treaties out there that's not within the scope of the present convention, and these are the stipulations involved with it. The fact that the present convention does not apply to international agreements concluded between states and other subjects of international law, or between such other subjects of international law, or to international agreements not in written form shall not affect these items right here. The legal force of such agreements, the application to them, or the application of the convention to the relations of states. But it's always between states, as you can see here. It's always about states. Article 4, non-retroactivity of the present convention. Without prejudice to the application of any rules set forth in the present convention to which treaties would be subject under international law independently of the convention. The convention applies only to treaties which are concluded by states after the entry into force of the present convention with regard to such states. And keep in mind, when a treaty is entered into force, it only happens after the contracting parties or the negotiating states, right, who drew it up, ratify it, and deposit it with the proper depository. So as we already know, and if you don't know now, you'll find out, the Treaty of Madrid, the depository was in Tangiers. The Act of Algeciras, the depository was in Madrid, right? Currently, the depository is the United Nations. The Montevideo Convention, the depository was the Pan-American something. I forgot the name of that depository, but it was in Washington, D.C. And so currently, the depository is the United Nations. So you would ratify and deposit your treaty with the United Nations After that point, it will become it would enter into force. All right. Meaning that it can now be exercised by both or more parties, depending on how many states are part of the treaties, whether it's bilateral or multilateral, meaning 2 or more. Article 5, treaties constituting international organizations and treaties adopted within an international organization. So this is dealing with international organizations such as who? The United States, not of America, but the United States, the municipal corporation. Internationally, they would be considered an international organization, which means they're not a state, which means they don't get to use the uppercase state, the uppercase S on states. Those are for organic states. The United States International Organization will be a lowercase s. Islam. The present convention applies to any treaty which is the constituent instrument of an international organization, and to any treaty adopted within an international organization without prejudice to any relevant rules of the organization. In other words, international law supersedes municipal law as it relates to the United States. Did y'all see that? I'll read it again. The present convention applies to any treaty which is the constituent instrument of any international organization, and to any treaty adopted within an international organization without prejudice to any relevant rules of the organization. All right. Part 2, conclusion and entry into force of treaties. Section 1, conclusion of treaties. Article 6, capacity of states to conclude treaties. Every state possesses capacity to conclude treaties. Every state, uppercase letter S, state. Every state possesses capacity to conclude treaties. Islam, good brother Akil, I see your message. Article 7, full powers. 1, a person is considered as representing a state for the purpose of adopting or authenticating the text of a treaty, or for the purpose of expressing the consent of the state to be bound by a treaty if he produces appropriate full powers. So what's giving us our full? What gives AMPAG? May I ask a question to the floor? Anyone can answer, please. What gives AMPAG, NUMECA, or Maru full powers?
Our state constitution.
That's halfway answered.
Okay.
Checking all the boxes, creating a constitution, having your voting done, doing your election of state members, sending in your documents to the proper location, and then you have full powers.
That's correct. More specifically,
not to mention your flags and your seal and all that. Yes.
That's correct. That's correct. The short version of that answer, which I was looking for, is a ratified, deposited, and promulgated constitution. But all that you said, Sister Makara, that's correct. All those is necessary. But in the end, a ratified, deposited constitution gives you the full powers to operate as a state. All right. So A, he produces appropriate full powers, or B, it appears from the practice of the states concerned or from other circumstances that their intentions was to consider that person as representing the state for such purposes and to dispense with full powers. All right. And then 2, in virtue of their functions and without having to produce full powers, the following are considered as representing their states. So it says, in virtue of their functions and without having to produce full powers, the following are considered as representing their state. Heads of state, heads of government, and ministers of foreign affairs for the purpose of performing all acts relating to the conclusion of a treaty. B, heads of diplomatic missions for the purpose of adopting the text of a treaty between the accrediting state and the state to which they are accredited. And then C, representatives accredited by states to an international conference or to an international organization or one of its organs for the purpose of adopting the text of a treaty in that conference, organization, or organ. All right. Does that make sense to everyone? Does everyone understand that? In virtue of their functions and without having to produce full powers, the following are considered as representing their state. So the heads of state, the head of government, and ministers of foreign affairs for the purpose of performing all acts relating to the conclusion of a treaty. In that case, they don't have to produce full powers. Or B, heads of diplomatic missions for the purpose of adopting the text of a treaty between the accrediting state and the state of which they are accredited. And then C, representatives accredited by the state to an international conference or to an international organization or one of its organs for the purpose of adopting the text of a treaty in that conference, organization, or organ. But these are the reasons why you wouldn't have to produce full powers. Article 8, subsequent confirmation of an act performed without authorization. Subsequent confirmation of an act performed without authorization. An act relating to the conclusion of a treaty performed by a person who cannot be considered under Article 7 as authorized to represent a state for that purpose is without legal effect unless afterwards confirmed by that state. An act relating to the conclusion of a treaty performed by a person who cannot be considered under Article 7 as authorized to represent a state for that purpose is without legal effect unless afterwards confirmed by the state. Article 9, adoption of the text. 1, the adoption of the text of a treaty takes place by the consent of all the states participating in its drawing up except as provided in paragraph 2. 2, the adoption of the text of a treaty at an international conference takes place by the vote of 2/3 of the states present and voting, unless by the same majority they shall decide to apply a different rule. All right. Article 10, authentication of the text. The text of a treaty is established as authentic and definitive. B, by such procedures as may be provided for in the text or agreed upon by the states participating in its drawing up. Or B, failing such procedure by the signature ad referendum or initiating by the representatives of those states of the text of the treaty or of the final act of a conference incorporating the text. All right, Article 11, means of expressing consent to be bound by a treaty. The consent of a state to be bound by a treaty may be expressed by signature, exchange of instruments constituting, I'm sorry. I was trying to say constituents. Constituting a treaty, ratification, acceptance, approval, or accession, or by any other means, if so agreed. Article 12, consent to be bound by a treaty expressed by signature. 1, the consent of a state to be bound by a treaty is expressed by the signature of its representatives when A, the treaty provides that signature, the treaty provides that signature shall have that effect. B, it is otherwise established that the negotiating states were agreed that signature should have that effect. Or C, the intention of the state to give that effect to the signature appears from the full powers of its representative or was expressed during the negotiation. 2, for the purposes of paragraph 1, A, the initiating initialing. I keep wanting to say initiating.
Yeah.
I appreciate that, good brother. But let's look at what initialing means. You got to look these words up. Like the good brother said, we can't be skimming through words or skimming through the readings. Okay, so initialing. Mark or sign a document with one's initials. Oh, initialing. Oh, okay, yeah. Your initials. One's initials in order to authorize or validate it. So that's what initialing means. I've been reading it all wrong or pronouncing it all wrong. Initiating. I'm sorry, y'all. Thank you. I need y'all. I need y'all because I'm just not perfect. I know I come off as though I am, but I'm not. All right. The initialing of
Nah,
a
we got
text.
your back.
I appreciate that, good brother. I need
That was funny. That was funny.
Well, you know, I gotta crack a little jokes there and there, you know, keep things light. The initialing of a text constitutes a signature. Okay, so now the reading makes more sense. The initialing of a text constitutes a signature of the treaty when it is established that the negotiating states so agreed. So the negotiating states got to agree to the initialing as given it as it being your signature. Or B, the signature at referendum of a treaty by a representative, if confirmed by his state, constitutes a full signature of the treaty. All right. Article 13. Consent to be bound by a treaty expressed by an exchange of instruments constituting a treaty. The consent of states to be bound by a treaty constituted by instruments exchanged between them is expressed by that exchange when A, the instruments provide that their exchange shall have the effect or have that effect, or B, it is otherwise established that those states were agreed that the exchange of instruments should have that effect. Article 14, consent to be bound by a treaty expressed by ratification, acceptance, or approval. All right, so Makara, you're on the line. And you heard the things that I said to Akil about full powers in the session and ratification and things of that nature. So Article 14 is going to address that to a degree, as we see in the title of the article, consent to be bound by a treaty expressed by. So your ratification, acceptance, or approval is what expresses you being bound, your state being bound to the treaty.
Mhm.
The consent of a state to be bound by a treaty is expressed by ratification when A, the treaty provides for such consent to be expressed by means of ratification. B, it is otherwise established that the negotiating states were agreed that ratification should be required, which I haven't read a treaty yet that didn't require ratification. C, the representative of the state has signed the treaty subject to ratification. Or D, the intention of the state to sign the treaty subject to ratification appears from the full powers of its representative or was expressed during the negotiation, right? So it has to be agreed upon beforehand. 2, the consent of a state to be bound by a treaty is expressed by acceptance or approval under conditions similar to those which apply to ratification. Article 15. Any subject of Morocco must choose between the entire. That's Article 15. That's the Treaty of Madrid. Article 15. Consent to be bound by a treaty expressed by accession. The consent of a state to be bound by a treaty is expressed by accession when the treaty provides that such consent may be expressed by that state by means of accession. B, it is otherwise established that the negotiating states were agreed that such consent may be expressed by that state by means of accession. And C, all the parties have subsequently agreed that such consent may be expressed by that state by means of accession. All right. Article 16, exchange or deposit of instruments of ratification, acceptance, approval, or accession. So these Article 15, Article 16 is what makes the treaty or convention or whatever become in full force or in force. Okay, because you have to ratify it and deposit it. So Article 16 says exchange or deposit of instruments of ratification, acceptance, approval, or accession. Let's do this here real quick. Let's go here real quick. Any treaty, I've already got one pulled up. Let's say this one here. Okay, so this is the Treaty of Peace and Friendship. It says this treaty shall continue in full force with the help of God for 50 years, after the expiration of which term the treaty shall continue to be binding on both parties until the one shall give 12 months notice to the other of an intention to abandon it, in which case its operation shall cease at the end of the 12 months. That's what I was explaining earlier. This is not a good example. Let me go to another one. This is a better example here. Come on, baby. This is a better example. I think it would be Article 18. Okay. Blow it up a little bit more. All right. The convention shall be ratified, or this convention shall be ratified. The ratifications shall be exchanged at Tangier with as little delay as possible. Okay, so it's got to be ratified. I can't. Okay, it's supposed to be. It needs to be ratified, and the ratification needs to be deposited. Where? At Tangier, with as little delay as possible. By exceptional consent of the high contracting parties, the stipulations of this convention shall take effect on the day on which it is signed at Madrid. In fate whereof, the respective plenipotentiaries have signed this convention and have thereunto affixed the seal of their arms. Done at Madrid in 13 originals, this 3rd day of July 880. So what am I showing here? The beginning of Article 18. It says this convention shall be ratified. The ratification shall be exchanged at Tangier with as little delay as possible. All right. So let's go back to the reading. What does that say? So Article 15 deals with, well, this is the accession. This is when we accede to it. Article 16 deals with exchange or deposit of exchange. Then we just read that word, exchange. And we also read the word ratification. So it needs to be ratified and exchanged in Tangier, or Treaty of Madrid does. That's the treaty we just went over, the Article 18 of the Treaty of Madrid. So it says, unless the treaty otherwise provides, instruments of ratification, acceptance, approval, or accession establish the consent of a state to be bound by a treaty upon A, their exchange between the contracting states, B, their deposit with the depository, or C, their notification to the contracting states or to the depository, if so agreed. This is what gives it full powers, or gives it the status of being in full force, is the ratification, depository, and exchange of the document. All right, as we just read. And so this also proves that Moroccan law is the foundation to international law, because this Vienna Convention Treaty on the laws of treaties is not Moroccan law per se, from the perspective that Moroccans wrote this treaty, but Moroccans wrote the Treaty of Madrid. Moroccans wrote the Treaty of Peace, and also the Act of Algeciras. The Moxons wrote that on behalf of the Sultan, and it became the foundation for all of international law. That's why you can easily read these treaties and these later treaties and conventions that came from the charter, and you would find that it's using similar language to the older treaties that are actually Moroccan treaties, i.e., Moroccan law is the foundation to international law. This should give you a sense of power. Like I was saying in the other class, or in the last discussion, we have to come to the mindset of Luke Skywalker when he beheaded Darth Vader. We have to come to the mindset of Neo of the Matrix when he jumped inside of Agent Smith, and when he stopped the bullets with one hand. They came to that point. They came to that point in their lives, according to the movies, when they finally let go of the blockage in their minds that had them in fear, that had them outside of their full faith and belief in themselves. And so when you understand that Moroccan law is the foundation to international law, that should give you the power to understand the authority that we have over the United States and any other foreign power, especially those who are the signatory powers of both the Treaty of Madrid and the Act of Algeciras. Now we know that 11 of the signatory powers backed out of the Act of Algeciras. But who remained? The United States. That's who mattered the most, because that's who we're dealing with. And agreements must be kept. This is how we know we're going to beat the United States in the treaty in the International Court of Justice. Because it's one thing for you to violate the treaties when you're dealing with ipso dromore subjects who are individualized all over the place, trying to gain remedy as individuals. It's a whole nother for them to try to violate the treaties when you come with your Moroccan state. Because what? Pacta sunt servanda, right? Means what? Agreements must be kept? Is that the word? That is the word. Pacta sunt servanda? No, that's not the word. That is the word, isn't it? Let's go back up. I gotta memorize this word. It is it. Pacta sunt servanda. I did memorize it. See? No belief in myself. All right, let's go back. We have to know that we have these authorities. We have to know that we have the power. We have to know that the United States does not have authority over us. We have to know that the United States cannot interfere with our domestic affairs. We have to know that use of force has been outlawed, and the United States cannot use use of force against us. Why? Because our Moroccan law says so. And that's without us being in power. And they still have to adhere to that. So now imagine when we come into power. We have to recognize this in ourselves, period. There's no way around it if we want to be successful in defeating this beast. Article 17, consent to be bound by part of a treaty and choice of deferring provisions. 1, without prejudice to Articles 19 to 23 through 23 or to 23, the consent of a state to be bound by part of a treaty is effective only if the treaty so permits or the other contracting states so agree. 2, the consent of a state to be bound by a treaty which permits a choice between differing provisions is effective only if it is made clear to which of the provisions the consent relates. Now, the Act of Algeciras, wherever there's a conflict with any of the treaty provisions, which treaty has the authority? The Act of Algeciras. Which article is that? The last article. Let's examine it real quick. Act of Algeciras. Article 116. I think. Okay. No. In case of disagreement between the competent administration, this jury, where is it at? General provisions. It should be in general provisions. That's not it. let's see, Article 21, 121, 123, I think is what it is. Okay, yeah, Article 123. And last, all treaties, conventions, and agreements, all, not part, not some, all treaties, all treaties, I'll say it again, all treaties, conventions, and arrangements of the signatory powers with Morocco remain in force. It is understood, however, that in case of conflict between their provisions and those of the present act, the stipulations of the latter shall prevail. So the stipulations of the general act shall prevail wherever there's a conflict between the provisions of those of the present act. In fate whereof, the delegates plenipotentiaries have signed the present general act and have affixed their seal thereto. Okay, but let's go back to 122. Look at what this says. Again, echoing Moroccan law. The Vienna Convention on the Treaty of Laws has been echoing the Moroccan laws. How? Well, the present General Act shall enter into effect as soon as all the ratifications shall have been deposited, and at the latest on December 31st, 1906. In case of special legislative measures which may be necessary in certain countries to ensure the application to their nationals living in Morocco of certain stipulations. See, their nationals living in Morocco of certain stipulations of this present General Act shall not have been enacted by the date fixed for ratification. These stipulations shall only become applicable in respect to them after the legislative measures above referred to shall have been promulgated. This is the Act of Algeciras, 1906. And then 121 also says, keeping in mind, this is the general provisions, the proviso. The present General Act shall be ratified according to the constitutional laws of each state. The ratification shall be deposited at Madrid as soon as practicable, and at the latest by December 31st, 1906. A process verbal shall be made of such deposit and a certified copy sent to each of the signatory powers through the diplomatic channel. That's the exchange that the treaty was talking about. It get exchanged between the signatory powers of the state. So I came here to show you that these treaties echo our, and this is a convention, it echoes our treaties. So if there's a conflicting provision with the Act of Algeciras, the Act of Algeciras is what will prevail. Period. Why is that? Why? Because it's Moroccan law. Moroccan law supersedes it all. Moroccan law is the supreme law of the land. International law is based in Moroccan law. I'm showing and proving here how the Vienna Convention of 1969, which comes from the Charter, is echoing the Act of Algeciras and the Treaty of Madrid. Ratification, depository, promulgation, exchange. The same language. 2. So back to 2. The consent of a state to be bound by a treaty which permits a choice between differing provisions is effective only if it is made clear to which of the provisions the consent relates. Article 18. Obligation not to defeat the object and purpose of a treaty prior to its entry into force. A state is obliged to refrain from acts which would defeat the object and purpose of a treaty when it has signed the treaty or has exchanged instruments, here we go again, constituting the treaty subject to ratification, acceptance, or approval until it shall have made its intention clear not to become a party to the treaty. Or B, it has expressed its consent to be bound by the treaty, pending the entry into force of the treaty and provided that such entry into force is not unduly delayed. They're using the same language. Section 2, reservations. Article 19, formulation of reservations. A state may, when signing, ratifying, accepting, approving, or acceding to a treaty, formulate a reservation unless A, the reservation is prohibited by the treaty. B, the treaty provides that only specified reservations, which do not include the reservation in question, may be made. So it's like it's giving you the leeway to identify in which direction the signatory powers must go, and of course, as it relates to the treaty, based on when you draw it up. At that point is when you must identify how it's going to be handled, not after, but beforehand. See, in cases not failing under subparagraphs A and B, the reservation is incompatible with the object and purpose of the treaty. Article 20, acceptance of an objection to reservations. 1, a reservation expressly authorized by a treaty does not require any subsequent acceptance by the other contracting states unless the treaty so provides. 2, when it appears from the limited number of the negotiating states and the object and purpose of a treaty that the application of the treaty in its entirety between all the parties is an essential condition of the consent of each one to be bound by the treaty. A reservation requires acceptance by all the parties. All right? 3, when a treaty is a constituent instrument of an international organization, and unless it otherwise provides, a reservation requires the acceptance of the competent organ of that organization. 4, in cases not falling under the preceding paragraphs, and unless the treaty otherwise provides. A, acceptance by another contracting state of a reservation constitutes the reserving state a party to the treaty in relation to that other state if or when the treaty is enforced for those states, and more states, uppercase S, by the way. B, an objection by another contracting state to a reservation does not preclude the entry into force of the treaty as between the objecting and reserving states, unless a contrary intention is definitely expressed by the objecting state. C, an act expressing a state's consent to be bound by the treaty and containing a reservation is effective as soon as at least one other contracting state has accepted the reservation. And then 5, for the purposes of paragraphs 2 and 4, and unless the treaty otherwise provides, a reservation is considered to have been accepted by a state if it shall have raised no objection to the reservation by the end of a period of 12 months after it was notified of the reservation or by the date on which it expressed its consent to be bound by the treaty, whichever is later. Article 21, legal effects of reservations and of objections to reservations. Are there any questions or statements or comments before I go any further? I don't want to be the only one reading. If anyone has something to say, I'll give you a couple of minutes to speak your piece. I'm listening.
No, I'm good. It's Brother Floyd. I'm good.
Oh yeah, I know you good, because if you weren't good, you would have jumped in and said what you had. Islam. All right. Legal effects of reservations and of objections to reservations. And again, I'm glad you're here, good brother. I've been missing you, man. I love it when you on. Number 1, a reservation established with regard to another party in accordance with Articles 19, 20, and 23. A, modifies for the reserving state in its relations with that other party the provisions of the treaty to which the reservation relates to the extent of the reservation, and B, modifies those provisions to the same extent for that other party in its relations with the reserving state. 2, the reservation does not modify the provisions of the treaty for the other parties to the treaty inter se. Inter se. Does anybody knows what inter se means? Well, we're going to find out. What is inter se? Where are we? Okay. Let's see what inter se means. Inter se meaning. Inter se, between or among themselves. So inter se means between or among themselves. So let's go back. So the reservation does not modify the provisions of the treaty for the other parties to the treaty inter se. Now we know what inter se means. In and between the two parties. 3, when a state objecting to a reservation has not opposed the entry into force of the treaty between itself and the reserving state, the provisions to which the reservation relates do not apply as between the two states to the extent of the reservation. Notice I keep stressing the word states. Withdrawal of reservations and of objections to reservations. 1, unless the treaty otherwise provides, a reservation may be withdrawn at any time, and the consent of a state which has accepted the reservation is not required for its withdrawal. 2, unless the treaty otherwise provides, an objection to a reservation may be withdrawn at any time. And then 3, unless the treaty otherwise provides or it is otherwise agreed, A, the withdrawal of a reservation becomes operative in relation to another contracting state only when notice of it has been received by that state. And B, the withdrawal of an objection to a reservation becomes operative only when notice of it has been received by the state which formulated the reservation. Article 23, procedure regarding reservations. So what is the procedures regarding reservations? Let's find out. 1, a reservation, an express acceptance of a reservation, and an objection to a reservation must be formulated in writing and communicated to the contracting states and other states entitled to become parties to that treaty. 2, if formulated when signing the treaty subject to ratification, acceptance, or approval, a reservation must be formally confirmed by the reserving state when expressing its consent to be bound by the treaty. In such a case, the reservation shall be considered as having been made on the date of its confirmation. It's always all about the date. That's why you'll see that the older treaties would tell you that it needs to get done. The ratification and the acceptance and the deposit of the treaty must be done by a certain date. It's always about the date. When you send off Makara, when you all send off your documents, you have to be mindful of the date that it was sent off. That date, correct. Exactly. You want to hold on to that. You send it certified. You want to hold on to that green copy because that's that's the date in which you have achieved your full powers. Gotcha. It's all about the date. 3, an express acceptance of or an objection to a reservation made previously to confirmation of the reservation does not itself require confirmation. 4, the withdrawal of a reservation or of an objection to a reservation must be formulated in writing. Section 3, entry into force and provisional application of treaties. Article 24, entry into force. 1. A treaty enters into force in such manner and upon such date as it may provide or as the negotiating states may agree. 2. Failing any such provisions or agreement, a treaty enters into force as soon as consent to be bound by the treaty has been established for all the negotiating states. 3. When the consent of a state to be bound by a treaty is established on a date after the treaty has come into force, the treaty enters into force for that state on that date, unless the treaty otherwise provides. 4. The provisions of a treaty regulating the authentication of its text, the establishment of the consent of states to be bound by the treaty, the manner or date of its entry into force, reservations, the functions of the depository, and other matters arising necessarily before the entry into force of the treaty apply from the time of the adoption of its text. All right. Article 25, provisional applications. So studying the this particular convention is what's going to allow us to establish the treaty that's going to bring our states together. So we have to understand these principles in order for us to write our own treaty for AMPAG, New Mecca, AMPAG, Maru, and DMT when DMT come online, and any other state for that matter. 1. A treaty or a part of a treaty is which means that we have to follow the instructions even when it comes to that. You can't just do whatever we want, right? We have to follow the instructions according to the rules of the game. And this is in politics, it's chess. And in chess, there's rules. You can't get on the table, you can't get on the board with with your pieces and start moving pieces as you see fit. It won't work. You will look incompetent. You will be laughed out of the place wherever you are playing this chess game, this chess match. You have to move the pieces and operate the game in conformity with the rules that was established for the game. That's the same thing with politics. It's the same thing with statehood. It's the same thing with governments. We must follow the rules, and agreements must be kept. All right, in the strict sense of the word. 1. A treaty or a part of a treaty is applied provisionally pending its entry into force if A, the treaty itself so provides, or B, the negotiating states have in some other manner so agreed. 2. Unless the treaty otherwise provides or the negotiating states have otherwise agreed, the provisional application of a treaty or a part of a treaty with respect to a state shall be terminated if that state notifies the other states between which the treaty is being applied provisionally of its intention not to become a party to the treaty. All right, so you're not forced into it. It's by your own choice, right? So your right to self-determination. But once you lock in, you lock in. But most treaties you can always back out of it with the proper protocol, which more than likely deals with notifying the other states in writing. And there's a time period before you can do so, usually a year. Part 3. And that's what happened with the Treaty of Fez. The Treaty of Fez was dissolved in 1956. That was a bilateral treaty between France and Morocco. All right. So when the Sultan became demoted himself to king for the created a modern state in the Kingdom of Morocco, that treaty between France and Morocco was dissolved based on their own negotiation. All right, so you can always dissolve a treaty, back out of a treaty. You're not stuck with it. I mean, the other 11 signatory powers of the Act of the Act of Algeciras, they backed out of the treaty. You see, but there was prior written notice. Article 26, Pacta Sunt Servanta, my favorite word. Agreements must be kept. Every treaty in force is binding upon the parties to it and must be performed by them in good faith. That's another, I believe they got that off the Treaty of Peace and Friendship. It has to be performed in good faith. That's Pacta Sunt Servanta. The agreements must be kept. Every treaty in force is binding upon the parties to it and must be performed by them in good faith. You're bound by it. As long as you're a part, unless you're a signatory, as long as you're a signatory power to it, you are bound to it. All right. Article 27. But there's other but international law as a whole, any state is bound to the laws. So, you know, if you're operating as a state internationally, you may not necessarily be a signatory power to the treaty to this convention, which is the Convention on the Laws of Treaties, right? You may not be a signatory power to it, but you're still bound to it because it's the rules of engagement internationally. You can't say, okay, well, I'm not going to be a part of that treaty because I don't like the fact that it's saying that we cannot use of force. So that because what you're trying to do is circumvent that particular provision so that you could use of force, but it's outlawed across the board. So you can't do it anyway, whether you're a part of it or not. You understand what I'm saying? So Article 27, internal law and observance of treaties. AMPAG, DMT, let's pay attention to this one because we're talking about internal laws and observance of treaties. A party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. This rule is without prejudice to Article 46, period. A party may not invoke, and keep in mind, party is a state. A person is a state. A party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. United States, you can't use your municipal laws as a justification to go against any treaty, especially those dealing with anything dealing with just cogence or human rights. You just can't do it. But again, it's between states and states. It's not between states and your nationals or states and your citizens. Those are internal laws. And you can basically almost do whatever you want within your state. Obviously, us at AMPAG, we're operating strictly under love, truth, peace, freedom, and justice. So we will not allow any form of human rights violation for our nationals within our state. Right? Though we could, but we will not. Why can't we do it? Because no other powers can interfere with us. The only time the only time the United Nations or any other international organization can interfere is if we're dealing with a dispute between states. So like the United Nations has the right to interfere with Russia and Ukraine, for example, right? Because they're violating the human rights of the state and therefore their nationals or their citizens or whatever. All right. Section 2, application of treaties. Article 28, non-retroactivity of treaties. Unless a different intention appears from the treaty or is otherwise established, its provisions do not bind a party in relation to any act or fact which took place or any situation which ceased to exist before the date of the entry into force of the treaty with respect to that party. All right. Article 29, territorial scope of treaties. Unless a different intention appears from the treaty or is otherwise established, a treaty is binding upon each party in respect to its entire territory. All right. Article 30, application of successive treaties relating to the same subject matter. 1, subject to Article 103 of the Charter of the United Nations, the rights and obligations of states, parties to successive treaties relating to the same subject matter shall be determined in accordance with the following paragraphs. 2, when a treaty specifies that it is subject to or that it is not to be considered as incompatible with an earlier or later treaty, the provisions of that other treaty prevails. Right? A lot of this stuff is self-explanatory. 3, when all the parties to the earlier treaty are parties also to the latter treaty, but the earlier treaty is not terminated or suspended in operation under Article 59, the earlier treaty applies only to the extent that its provisions are compatible with those of the later treaty. Okay? 4, when the parties to the later treaty do not include all the parties to the earlier one, A, as between states parties to both treaties, the same rule applies as in paragraph 3. B, as between a state party to both parties and a state party to only one of the treaties, the treaty to which both states are parties governs their mutual rights and obligations. By the way, anyone who may want a copy of this particular document, let me know. And I'll email it to you, no problem. So you can read over it and study it, especially you, Sister Makara. Okay, 5.
I already have it. Thank you.
Good. I should have known. Okay, 5. Paragraph 4 is without prejudice to Article 41, or to any question of the termination or suspension of the operation of a treaty under Article 60, or to any question of responsibility which may arise for a state from the conclusion or application of a treaty, the provisions of which are incompatible with its obligations towards another state under another treaty. All right. Section 3, interpretation of treaties. Article 31, general rule of interpretation. 1, a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty and in their context and in the light of its object and purpose. 2, the context of the purpose of the interpretation of a treaty shall comprise, in addition to the text, including its preamble and annexes. The preamble is important. Let me see if somebody can answer this. Why is the preamble to a treaty so important? This is important, y'all. Why do y'all think, why do you think that the preamble
Does
is
it
so
set
important?
up the guidelines of the contract?
No, it shows who the parties are.
That's one reason.
It gives you a heads up of what you're about to get into.
That's correct. Both of you are correct. It tells you who the signatory powers are, and it also tells you, it gives you the content and the context for what the treaty is all about. Without that, then you wouldn't even know what you're reading. You got to know the preamble. You got to understand what the preamble says in order for you to understand the rest of the treaty. A, any agreement relating to the treaty which was made between all the parties in connection with the conclusion of the treaty. B, any instrument which was made by one or more parties in connection with the conclusion of the treaty and accepted by the other parties as an instrument related to the treaty. 3, there shall be taken into account, together with the context, A, any subsequent agreement between the parties regarding the interpretation of the treaty or the application of its proviso or provisions. B, any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation. C, any relevant rules of international law applicable in the relations between the parties. 4, a special meaning shall be given to a term if it is established that the parties so intended. Article 32, supplementary means of interpretation. Recourse may be had to supplementary means of interpretation, including the preparatory work of the treaty and the circumstances of its conclusion, in order to confirm the meaning resulting from the application of Article 31, or to determine the meaning when the interpretation according to Article 31A leaves the meaning ambiguous or obscure, or B, leads to a result which is manifestedly absurd or unreasonable. Article 33, interpretation of treaties authenticated in 2 or more languages. Okay, let's see. I'm going to engage y'all tonight. What are the 2 languages that's utilized in international law, especially as it relates to the International Court of Justice? Shoot, anyone.
English and French.
French and English.
More specifically, French and English. French comes first because France had the power of the pen at the time when they established the charter.
That was the first language. Go ahead.
No. Go ahead. Say that again. What were you going to say?
No, I was saying that was the first language that they printed it in. They printed it in that first before they did English.
Actually, no. They printed it in English first.
Oh, okay. I knew it was one of them when they discussed it.
Yeah, they printed it in English first. At the time, France was, I guess you can say, defeated. But then they came out of nowhere. Dang, my coffee got cold. That sucks. Anyway, and then somehow France came back because they had the power of the pen the whole time. Because remember, the Sultan gave them the pen during the Treaty of Fez. So they came in and bullied their way into the charter and made the French language part of it, and not just part of it, but the main aspect of it. So like when you look at the, let me show y'all something. This is the other form of the General Act of Algeciras. It's a harder read. Why is it a harder read? Because of this right here. Let me blow it up a little bit. If you see here, on the left is in French, knowing and understanding that the left side is the dominant side. That's why the Moorish flag flies on the left side, right? And the US flag flies on the right, or any other subordinate flag, such as AMPAG's flag is subordinate to the Moorish flag. But you notice here, it's French on the left, English on the right. All right? Those are the 2 languages, and it has to be in standardized English or French. All right, back to the reading. Just prove that point. Okay, when a treaty has been authenticated in 2 or more languages, the text, now, it doesn't mean that if you're, let's say, Burkina Faso and Nigeria coming together to establish a treaty, doesn't mean that it has to be in English and French. It could be in your native language. However, if you wanted to bring in the United Nations for whatever reason, or the ICJ, your documents would have to be in French and English, right? So it would have to be translated. But your actual treaty between the signatory powers, those could be in whatever language those signatory powers speak in, right? So just keep that in mind. When a treaty has been authenticated in 2 or more languages, the text is equally authoritative in each language, unless the treaty provides or the parties agreed that in case of divergence, a particular text shall prevail. All right. 2, A version of the treaty in a language other than one of those in which the text was authenticated shall be considered an authentic text only if the treaty so provides or the parties so agree. 3, the terms of the treaty are presumed to have the same meaning in each authentic text. 4, except where a particular text prevails in accordance with paragraph 1, when a comparison of the authentic text discloses a difference of meaning, which the application of Articles 31 and 32 does not remove the meaning which best reconciles the text, having regard to the object and purpose of the treaty shall be adopted. All right, so section 4, treaties and third states. Article 34, general rule regarding third states. A treaty does not create either obligations or rights for a third state without its consent. All right, so the third state got to gain consent from the signatory, the other signatory powers. That's how simple that one is. It's just one line. A treaty does not create either obligations or rights for a third party without its consent. So you don't have any obligations or rights without the consent of other parties. Article 35, treaties providing for obligations for third states. An obligation arises for a third state from a provision of a treaty if the parties to the treaty intend the provision to be the means of establishing the obligation and the third state expressly accepts that obligation in writing. 36, treaties providing for rights for third states. 1, a right arises for a third state from a provision of a treaty if the parties to the treaty intend the provisions to accord the right either to the third state or to a group of states to which it belongs, or to all states, and the third state assents thereto. Its assent shall be presumed so long as the contrary is not indicated unless the treaty otherwise provides. 2, a state exercising a right in accordance with paragraph 1 shall comply with the conditions for its exercise provided for in the treaty or established in conformity with the treaty. Article 37, revocation or modification of obligations or rights of third states. 1, when an obligation has arisen for a third state in conformity with Article 35, the obligation may be revoked or modified only with the consent of the parties to the treaty and of the third state, unless it is established that they had otherwise agreed. 2, when a right has arisen, or am I saying that right? Arisen or arisen? Arisen or arising. When a right has arisen, am I saying that right, y'all?
I would say arisen.
Arisen.
Yeah, okay. When a right has arisen for a third state in conformity with Article 36, the right may not be revoked or modified by the parties if it is established that the right was intended not to be revocable or subject to modification without the consent of the third state. Article 38, rules in a treaty becoming binding on third states through international custom. Nothing in Articles 34 to 37 precludes a rule set forth in a treaty from becoming binding upon a third state as a customary rule of international law, recognized as such. Part 4, amendment and modification of treaties. Article 39, general rule regarding the amendment of treaties. What time is it? 10:30. Ooh, Lord. We did get kind of started. We got started a little late. I think we'll stop and then we'll read a couple more articles and then we'll stop and pick up on it on the next call. A treaty may be amended by agreement between the parties. The rules laid down in Part 2 apply to such an agreement except insofar as the treaty may otherwise provide. Article 40, amendment of multilateral treaties. Unless the treaty otherwise provides, the amendment of multilateral treaties shall be governed by the following paragraphs. 2. Any proposal to amend a multilateral treaty as between all the parties must be notified to all the contracting states, each one of which shall have the right to take part in A, the decision as to the action to be taken in regard to such proposal. B, the negotiation and conclusion of any agreement for the amendment of the treaty. 3, every state entitled to become a party to the treaty shall also be entitled to become a party to the treaty as amended. All right. 4, the amending agreement does not bind any state already a party to the treaty, which does not become a party to the amending agreement. Article 30, paragraph 4, part B, applies in relation to such state. Any state which becomes a party to the treaty after the entry into force of the amending agreement shall, fail in an expression of a different intentions by that state, A, be considered as a party to the treaty as amended, and B, be considered as a party to the amended treaty in relation to any party to the treaty not bound by the amending agreement. Article 41. So obviously it could be amended, right? And when it is amended, all the signatory powers must be notified because it's a multilateral treaty. So that could be 2 is bilateral and 3 or more is multilateral. So if you got 20 states, all 20 must be notified. Agreements to modify multilateral treaties between certain of the parties only. 2 or more of the parties to a multilateral treaty may conclude an agreement to modify the treaty as between themselves alone if the possibility of, which that's very interesting. So if you got 10 parties, 2 of the 10 can amend the treaty for themselves. If that's what I'm reading correctly. 2 or more of the treaty parties to a multilateral treaty may conclude an agreement to modify the treaty as between themselves alone if, yep, that's what it's saying. A, there is the possibility of such a modification is provided for by the treaty. So the modification has to be provided for by the treaty. And B, the modification in question is not prohibited by the treaty, and I, or 1 really, does not affect the enjoyment. That's not 1, that's I. Whatever that is, does not affect the enjoyment by the other parties of their rights under the treaty or the performance of their obligations. And 2, does not relate to a provision, derogation from which is incompatible with the effective execution of the object and purpose of the treaty as a whole. 2, unless in a case falling under paragraph 1A, the treaty otherwise provides, the parties in question shall notify the other parties of their intention to conclude the agreement and of the modification to the treaty for which it provides. Part 5, invalidity, termination, and suspension of the operation of treaties. Section 1, general provisions. Article 42, validity and continuance in force of treaties. Let's see, 10:35 will be done. We'll finish it up at 10:40, and then we'll open up the floor till 11, and then we'll shut it down. I know people got to get up in the morning. Okay, 2, and I apologize for getting started late. 2, the termination of a treaty, its denunciation or the withdrawal of a party may take place only as a result of the application of the provisions of the treaty or of the present convention. The same rule applies to suspension of the operation of a treaty. Article 43, obligations imposed by international law independently of a treaty. The invalidity, termination, or denunciation of a treaty, the withdrawal of a party from it, or the suspension of its operation as a result of the application of the present convention or of the provisions of the treaty shall not in any way impair the duty of any state to fulfill any obligation embodied in the treaty to which it would be subject under international law independently of the treaty. Article 44, separability of treaty provisions. Then we'll stop here at Article 44. 1. A right of a party provided for in a treaty or arising under Article 56 to denounce, withdraw from, or suspend the operation of the treaty may be exercised only with respect to the whole treaty unless the treaty otherwise provides or the parties otherwise agree. 2. A ground for invalidating, terminating, withdrawing from, or suspending the operation of a treaty recognized in the present convention may be invoked only with respect to the whole treaty, except as provided in the following paragraphs or in Article 60. 3. If the ground relates solely to particular clauses, it may be invoked only with respect to those clauses where A, the said clauses are separable from the remainder of the treaty with regard to their application. B, it appears from the treaty or is otherwise established that acceptance of those clauses was not an essential basis of the consent of the other party or parties to be bound by the treaty as a whole. And C, continued performance of the remainder of the treaty would not be unjust. 4. In cases falling under Articles 49 and 50, the state entitled to invoke the fraud or corruption may do so with respect either to the whole treaty or subject to paragraph 3 to the particular clauses alone. And then 5, in cases falling under Articles 51, 52, and 53, no separation of the provisions of the treaty is permitted. So these are the rules. Where are we at? 44. Yep, Article 44. These are the rules thus far for how you would operate dealing with treaties. Is the laws of treaties. Islam. So we're stopped. That we'll stop there. We'll pick it up next week. Article 45, loss of a right to invoke a ground for invalidating, terminating, withdrawing from, or suspending the operation of a treaty. These things must be understood. Why? Because maybe we may want to terminate a treaty, suspend a treaty, whatever the case might be. We might want to terminate the Treaty of Peace and Friendship. We already have the instructions on what we need to do. That's in Article 25 of the Treaty of Peace and Friendship, 1836. However, we don't expect to do that. We're not necessarily looking to do that. Why is that? Well, we need taxpayers. And the United States is our wonderful taxpayers. So let's treat them accordingly. Islam, I open up the floor for any questions, comments, concerns, critiques. If you want to criticize me, I'm listening. Floor is open. Peace and love.
Who was that was doing the reading? What's your name?
Huh. My name is Abdul Bey, good brother. May I ask
Abdul
you?
Bey?
Yes, sir.
Oh,
May I ask you?
I'm Kendon.
You're who?
I'm Kendon here in Texas with them.
Oh, okay. Oh,
Yeah,
peace.
yeah, peace, brother, peace. Yeah, I mean, I don't know. It ain't too much to say. You know, it just really just kind of be repetitive and understanding. You know what I mean? For the most part, I guess just like a general perspective would just be, this is just how higher intelligent people deal with disputes. So
Exactly.
you just can kind of look at it like that and understand like how you're reading with that frame of mind when I listen to you. Like that's the perception I get, and it comes clear to me that way.
Well, I'm glad to hear that, good brother. And so you're coming on with Dimty, correct?
Correct.
Good. Well, I'm glad you're on the call, and I'm glad you're linking up with the good brother Coleman and Sister Makara. What will your position be, good brother?
The Kadi.
Kadi.
Correct.
Yeah, you want to be the tax man. You want to go after them dollars.
Yeah.
Islam. Well, welcome aboard, brother. You guys are doing an excellent job and excuse me, checking the boxes that's necessary to establish your states. I'm here to assist you all. Sister Makara knows, Brother Coleman already knows. So please continue checking the boxes, make it to the finish line, get it done. It's not that hard. It doesn't even require much finance. What it does require, however, is your diligent effort in making it happen. And thus far, what I've noticed, what I've seen with you all, you're definitely working it out. So congratulations on that. And we can't wait to have you come online, good brother.
Can I ask you, do you have like, what can I read specifically for us on the Qadi's position of some of his duties?
The tax codes, learn their tax codes.
Okay. The IRS, correct?
That's correct.
Okay.
Because eventually what you'll be doing anyway is converting their tax code laws to your Moroccan laws. That's one thing you'll do. Also, you'll be learning about the process. But more importantly, outside of their tax codes, the Act of Algeciras. Let's go to the Act of Algeciras real quick. This is the Act of Algeciras. Let's do something here for you. So we can show you something here. Let's see. So they got the word Qadi is in here twice. All right. So what does it say? Let's go to the beginning of the article. Article 60.
Okay, I'm gonna listen to you too. I'm driving. I just picked my kids up, so but I'm listening. I'm paying attention.
No problem.
Okay.
Article 60. In accordance with the right granted by Article 11 of the Madrid Convention, right? That's the Treaty of Madrid, 1880. Foreigners shall have the right to acquire property throughout the Sharifian Empire, and His Majesty the Sultan shall issue to his administrative and judicial officers such instructions as may be necessary for them not to refuse the registration of deeds without lawful cause. Subsequent transfers, either by deeds between living parties or by death, shall continue without hindrance. In the ports open to commerce and within a radius of 10 kilometers around such ports, His Majesty the Sultan, generally and without it being necessary henceforth for foreign subjects to obtain a special permission for each purchase of property, now grants the consent required by Article 11 of the Madrid Convention. At Khazar el Kabir, Arzila, Azamor, and eventually in other towns of the coast or the interior, the general authorization stated above is likewise granted to foreigners, but only for purchasers within a radius of 2 kilometers around those towns. Wherever foreigners may have acquired property, they will be permitted to erect buildings in compliance with regulations and usage. Before authorizing the execution of deeds for transferring property, the Qadi will have to satisfy himself of the validity of the title in conformity to the Mohammedan law. The Moxen shall designate in each city and district specified in this article the Qadi who shall have charge of such verification. That's where you come in, good brother. You are the Qadi, so you have to be at the closing to verify the validity of the titles, etc. Do you understand, good brother?
Yeah, I understand.
Yeah.
Thank you, too.
Yeah, no problem, good brother. That's what you want to study is the Act of Algeciras. In this particular chapter, you can pay close attention to chapter 4, a declaration concerning a better return of taxes and the creation of new revenues. So all the chapters, you want to focus more on chapter 4 to answer your question more directly.
Okay, thank you again.
Islam, good brother. Thank you. Anyone else?
Islam, I have a question.
What was that?
I have a question.
I hope I have an answer. Shoot.
I don't know. Let's see. So we just read in the Treaty of Vienna, the law of treaties, that states have the right to amend treaties. Is that correct?
Yes.
Okay. So it was a section that was talking about when states are involved in multilateral treaties, two states have the ability to amend the treaty amongst themselves. Was that correct?
That's what I recall reading this indeed, good brother.
Okay. So my question is, why wasn't the Sultan of Morocco and the United States able to amend Article 15 of the Treaty of Madrid from 1880?
Ah, excellent question. Charlemagne is paying attention. Excellent question. Except wrong statement. It was a good question. Wrong statement. It wasn't the Sultan of Morocco. It was the King of Morocco. That's why he wasn't able to do it, because he was just the king. See, that comes after 1956 or during the 1956 era or after. Is
Right.
when the Kingdom of Morocco made contact or came with the United States, or the United States contacted them, either or. As a matter of fact, let's verify what was said. But that's the reason why, is because he had already demoted himself to being a sultan. I mean, a king. He was no longer the sultan.
Okay.
But if he was the sultan, then yeah, that would have been a problem. So it says a U.S. note of March 17, 1915. That was in 1959. See, it was 3 years after he became the king. So a U.S. note of March 17, 1959, addressed to the Moroccan Ministry of Foreign Affairs, referred to a note from the ministry dated October 8, 1958, in which the embassy had been informed that the Moroccan government had decided to strike all prescriptions relating to Moroccan nationality from the text of the Madrid Convention. The U.S. note said, in part, the government of the United States of America, having unilaterally relinquished certain rights in Morocco with the reemergence of Morocco into independence in 1956, considers that in line with historical developments, Article 15 of the Madrid Convention on Protection of 1880 has become obsolete and without effect. The government of the United States takes due cognizance, therefore, of the action taken by the Moroccan government as set forth in its above cited note, which the United States government understands to refer only to Article 15 of the Madrid Convention on Protection of 1880. So this all happened 1958 to 1959, which is after 1956, when the Sultan had already reduced himself to being a king. So at that point now, it was too late. Only the Sultan would have been able to strike that from the record.
Gotcha.
If that is your question. Mm-hmm.
Yeah, gotcha. Yeah.
Which is great. We were lucky. I'm glad it happened afterwards, because then it was too late at that point. So that was an excellent question and an excellent observation too, good brother. Thank you for that question.
Islam.
Hey, I got another question. I wasn't reading, but I was going along watching one of the videos, and he was just saying, like, we in charge of the arms. Okay, so to get, I guess the arms, it will be through legislation, and then just say through the legislation, then like how would that go? Like, what I'm saying? What would that look like to get that revenue?
Clarify your question a little more. You said revenue and you said arms. Which one are you talking about? I'll ask that question again.
As far as like taxing, like being over the arms. Like we have like the Moroccan, I guess, as far as like we are like to tax the arms, who gets the permits, have control of all over the arms or whatnot. So what do that process look like? Like to get that, in the system where they, whatever tax we supposed to get off the arms. So, the permit's supposed to come through, the Moroccan Empire.
Well, what does it look like is your question? Well, decolonization.
Okay.
In other words, we have to, what you're talking about is economic liberty without any inequality when we fully activate the act of Algeciras, and it does happen through legislation, right? And so, yes, to answer, you mentioned legislation. Yes, it's going to require legislation um, to get the United States to do as we need them to do, right? However, to further answer your question, it may or may not happen till after we go to the ICJ, because what they're gonna do is stall and play games, right, and not adhere to our Moroccan laws. Why is that? Well, because Jacob, right, which are the bankers, which are the Jews, they're not gonna just allow the United States to just acquiesce like that. Because why? They got too much to lose. They want to hold on to what they have. They want to hold on to the banking system. That's their power base. That's Jacob's power base. Who is Jacob again? That's the Jews. And so ultimately, we may end up having to take them to the International Court of Justice, in which after that that judgment has been passed, then we can now force the United States, based on our legislation, to do as we need them to do in accordance with the Act of Algeciras. So to answer your question, in order to take over the arms and to take over the taxes, to take over the law enforcement, military, public services, public works, the entire system, we must first create legislation, send them judicial orders, ministerial decrees and judicial orders from consular court. They will stall. They will pretend as if they hadn't received these documents. We then petition the United Nations, take them to the ICJ. The ICJ makes their judgment against the United States, which more than likely they will. And from that point on, we hit them again with legislation, and now they have to adhere to the legislation. So, yeah. So to answer your question, is going to take, more than likely, is going to take the ICJ as well as our legislation to get them to conform to our Moroccan laws of paying taxes and falling under the jurisdiction of Morocco in general, whether it be paying taxes or having to get permits for their guns or their arms, etc. That type of thing. If that answers your question, I hope it did.
Nah, you did. It be like, I be listening to this information. I be like, man, I don't think it ain't nothing else more important than this is.
There is nothing more important. Go ahead.
I can listen to it all day.
Well, I appreciate that. I love that. So then that means then that you should be dissecting all the AMPAG study sessions, because
I do.
Go ahead.
I apologize. I watch about 2 or 3 of them a day.
Good. Well, you got to know the new channel is going to be AMPAG Government. The old one that you've been watching, that one is going to be dissolved eventually. They're moving on to a new channel. It's called AMPAG Government. All the old videos will be transferred over to that channel, and all the new videos will be posted on that channel. So we're waiting on video 79. So keep an eye out for that one. I appreciate your passion and mindset as it relates to this. Like you said, there's nothing, I mean, absolutely nothing more important than this information. No one else is talking about this, okay? Others are attempting to do so, but they're not as competent because they haven't even checked those boxes. And they're really doing it as a form of commerce, because they're charging people for this information, $300, you know what I mean, or $25 donations at the door if they show up to your town. Same old BS from the past, but now they're using it with international law and statehood, and that's just egregious and it's unfortunate. But at least you have an option. You can go to AMPAG study sessions. You can come to AMPAG Media to gain that information that you need. We don't charge anyone. We don't do that. Our ulterior motives is economic liberty without any inequality. So if we're going to charge anybody, it's going to be the colonizers. But in order to make that happen, we need our states to come online. And so we will forego the present finances that can be made with this in order to make the proper finance, which is through economic liberty without any inequality, by forcing decolonization and forcing the colonizers to pay their damn taxes. Excuse my language, but I get passionate when it comes to this. And I think we all should be passionate when it comes to this. Islam.
I think like, you know, it's kind of like a understanding thing with most people, and you know they not realizing like really what a constitution is. You know what I mean? Because if you knew what a constitution is, like you wouldn't be speaking about their constitution, or you would have one. But like they just don't make sense. If you understand, really understand, like Jermaine be saying, what's going on, like you gotta pay attention and read. It's just a no-brainer, really.
It really is. It really is. But it's not for those, it's only for those like you. People that got the eyes to see and the ears to hear. Right. Everyone is not really into the information, and they certainly are not if they're already charging folks for patently frivolous processes that don't work, only to then not answer the phone when you start calling them, asking them what's up. They're not going to answer the phone. So this information is putting a hole in certain people's pockets. They don't want this to be out here like that, but it is what it is. We got to push this information because it's necessary that we establish our state government so that we can force decolonization. The ultimate goal is to force decolonization, period. Nothing more, nothing less. Decolonization is the goal.
Yeah, the money thing, like that's a thing too. You know what I'm saying? At one point in time, you know, I never looked for anything for free or anything. So, you know, going through this process, learning, you know, I'm kind of like laid back, you know, that's what that person wants, you know, for what they have. But then, you know, just like you're not even giving the right information, and you're putting people in front of a giant, you know what I mean? An individual in front of a state, and it really has no match. So, you know what I'm saying? It don't even make no sense. But you charging people, and you know what I mean? And man, it's crazy, like you say. You hustling the people.
It is crazy. And it's egregious, it's crazy, and it's unfortunate. And so that's why on the last class that we did, or the open session, that's why I went on this long rant about who the real enemy is. Can we recognize the colonizers or even the white man, so-called white man, the Albayans, as enemies? Yeah, we can. Did they do a lot of dirt? Well, yeah. What do you expect from them? But what's even more egregious is that our own has been helping them. Our own. If our own wasn't helping them, they wouldn't have been able to get but so far with this. In fact, they wouldn't have even gotten too far with this. They can't even win wars without Moors. They can't do anything without Moors. We're the ones that are helping them, whether directly or indirectly, whether through our leader guys or within ourselves, by continuing the acquiescence of our Moroccan governments. You see, and so that's why this information is so important, because we need our Moors, we need our Moors to come to the mindset of, one, their true identity and nationality, right? Two, the unity that the state brings and the full powers that the state brings, so that then we can now start enacting Moroccan laws. Because as I've just proven, that convention that we're going over, the Convention on the Laws of Treaties, is echoing Moroccan law. What Moroccan law? The treaties. The treaties is the foundation to international law, and these treaties are Moroccan laws. And so when you understand that, it gives you the confidence to know that what we're doing, that we are doing the correct things, as long as we are in conformity with international law, specifically just cogence, which is human rights and state rights. Islam, anyone else?
Islam, Moors. This is brother Floyd, HP owner, one of these days. But anyway, I wanted to make the analogy because I'm hearing a lot of wisdom there's a saying that I've heard coming up. Hey man, that pale skinned brother over there, he's a brother. He's my brother from another mother. And what I'm determining also is a phrase I didn't grow up hearing is, oh yeah, that Mo over there, my enemy, he's also a brother of another mother. So it's not so right. It's not so much that Albion, because the Albions, to my understanding, according to some history, were actually sent by some dog-skinned Moors from another mother.
Yeah, exactly.
I just wanted to drop that so I can stay vigilant, stay aware, and not be, what's the phrase I've heard also? Don't let the smooth taste fool you. As in, right, like what just happening at AMPAG recently. I'm really still appalled by that incident. I can't believe that a YouTube of the elephant in the room actually was put out. That right to this moment still kind of bothers me how I could take it upon myself to even go that far to insinuate the Sayuraha and the Aziz agreed to do such a thing. But with that, I yield the floor.
Islam, good brother. The good news is that it got settled, and it got settled competently. And I don't foresee this happening anymore. But the worst part of it all is that it came from the head of state. It came from the prime minister. That's wow.
That's wicked.
Yeah, it's pretty wicked. It's pretty daggone wicked, you know, when you're lying like that and you're not providing any type of proof. Yes, he put a affidavit on the website, but it was void of a signature. You don't do that. Where's the signature? Anybody could have typed that up. You know? So, you know, it is unfortunate, but that's my point when I say it's our own who's gonna hold us back, more so than the colonizers. It's been our own who has been holding us back all these years. And it's continuing. Keep in mind that that's not the first issue that they had, right? This is like their second issue. But the first issue wasn't publicized like that. It remained in-house, they cleaned it up, and it was all good. Now, this second issue was publicized, but it was a desperate attempt because he himself was being removed. He was already on probation. He had sanctions. He had a 6-month sanction.
I have a
Because
question
go ahead.
on what you were talking about, and I watched the video that he put up. Isn't that treason? Did he treasonous act that he did?
It's borderline treason, but it's mostly an insurrection or overthrow of the government. It's borderline treason though, but it ain't there.
When you say overthrow of the government, that's treason.
Well, the reason why I'm saying it's not treason is because it was an internal thing. It wasn't he wasn't like involving himself with an outside force to make this happen. See, if he was involving himself with an outside force to make it happen, then yes, it would have been treason. But it was just him being belligerent. So that's where, you know, you kind of he was told he was walking a line, but being as though he didn't involve anyone outside of the state or anything like that. It just basically is a insurrection or an overthrow of the government, an attempted overthrow of the government, which the United States themselves, they have legislation to govern that, against that, you know, which we can also take and use as our internal law or convert it to our internal law. But yeah, to answer your question, no, it wasn't really treason to the fullest. It wasn't treason to the fullest extent of the word, but I mean, it was borderline treason though. But it's the correct term would be a insurrection or a coup d'état. So it was really a coup d'état and an attempted overthrow of the government. But I hear you. Oh, I hear you. It was egregious nonetheless. We had something very similar happen in our state, but it remained in-house. You know, no one went out there posting things on Facebook, you know, YouTube or anything like that. We just dealt with it in-house. And that's how it should be. The funny thing about it is all this time, which has been about, I don't know, a year and a half or so since a little bit over a year and a half, actually, that AMPAG has been established. You never hear from him. You've never seen a video from him. He remains in the shadows. I barely talk to the guy. Talk to him every once in a while. We have these roundtable meetings every Saturday, not every Saturday, one Saturday a month. But you don't hear from him. Suddenly you hear from him. And what is it that you're hearing from him? Negative stuff, slander. While he was in a corner in some closet or something. So now, conversely, though, in comparison to that elephant in the room video, the public proclamation video has the mother, the matriarch, the Sayaraha, reading off the proclamation with the whole state standing behind her. Keeping in mind, the baby that you've seen in the video was born as a Moroccan national. That was the first baby to be born outside of the jurisdiction of the United States in the jurisdiction of a Moroccan state government. That was beautiful. So, but you know, this is to teach us a lesson on how we need to deal with our own nationals that act belligerent within our state. We must hold them accountable. There's no way that you should expect for us to hold the colonizers accountable, but then our Moors can do whatever the hell they want. No. It don't work that way. Everybody got to follow the strict sense of the law. What law? Our Moroccan law, specifically which one? Our constitutions. The Constitution is what sets forth the rules of engagement for our state, for our internal affairs, as well as any external affairs dealing with other foreign countries. It's a dual document. It protects you from foreign invaders or enemies, as well as internal nationals that are being belligerent, attempting to overthrow the government or anything of that nature. The Constitution is very important, and the Constitution will always prevail.
Hey, can I call you? Can I get your contact information?
You may.
Okay, thank you. I mean, however, you know, we'll do it.
You are the same brother with Dempsey, right?
Correct.
Okay, you can get my number from Akara or Coleman.
Okay, thank you.
Islam. What's your name, brother?
Minister Vaughn.
Minister Siobhan?
No, Kendon Vaughn, but I'm a minister.
Oh, okay, Islam, brother.
Islam.
Yeah, you can get my number. You can call me whenever you need it, whenever you have any questions or whatever.
Islam.
Coleman always calling me, blowing up my phone, asking me questions.
Man, I be calling him too. I be calling him almost every day. But I'm gonna be calling.
Well, you're welcome to call me. Just don't blow up my phone, but you can call me.
Nah, I ain't gonna do that. Islam.
Yeah. Islam, brother. Anyone else before we close out? So yes, so we just basically, to recap, we just showed and proved that treaties deal with states. International law deals with states, right? This is not an individual operation. We have to get out of the mindset of individuality. We have to go into the mindset of unity. How do you establish competent unity to deal with the United States governments? Moroccan state governments, to be exact, Sharifian authorities, Moxons. For far too long in the past 100 years plus, 200 years plus, we haven't had a state. That's the one thing that we're missing. And because of that, we're begging, marching, praying, and begging the United States and the colonizers, right? The Albayans, our enemies, up until this point. They will become our friends, but up until this point, they've been our enemies. We've been begging them to write legislation on our behalf. Affirmative action. Jesse Jackson and his affirmative action. Civil rights, etc. when the whole time we had the power of the pen to enact our own legislation for our own salvation to even govern the colonists. But you can't do something if you don't know. And when you don't know what you don't know, you don't know. But that was by design. And who was involved in that? Our own. One of them has already been exposed. We exposed them on in one of our classes. The Resolution 75 document, the Moorish American Society of Philadelphia. They were involved in the speedy Americanization of former Moors. It's in the document. It's in the document. And for some reason, some way, somehow, when we read that document, we just skimmed past all that. Didn't recognize what was being said. Part of the reason is probably or possibly because we didn't understand international law. And more specifically, understanding that that Americanization of us was a trick bag. See, it went over our heads probably because we think that we're Moorish Americans. We thought that we was Americans. We thought we are the original Americans. So when it says the speedy Americanization, it made us feel good. But when you understand international law and you understand the difference between Moroccans and Americans, then it no longer is it so great. We are not seeking Americanization. We're seeking our Moroccan nationality and taking the Americans and putting them under our jurisdiction because that's where they belong. We are home, they are not. We didn't land on Plymouth Rock. Plymouth Rock landed on us. And when Plymouth Rock landed on us, the Sultan gave them the authority to, gave them the recognition as a state. What state? The United States of America. So you will find Obama, Hillary Clinton, even Biden, recognizing that Morocco recognized them as a state. They've reaffirmed it. Obama did it even more eloquently. It was a long speech. Then turned around and signed the rights of indigenous peoples. You see? And so the problem lies within our own people. We have been more, should I say, dangerous for ourselves than anyone else. I mean, fast forward till a couple of days ago, the young brother Takeoff from Migos was killed. Who killed him? Was it the white man? Was it the Albayans? Was it the police? No. The other young rapper, Young Dolph, he was killed. Was it the white man? Was it the Albayans? Was it the police? No. The other rapper, Nipsey Hussle. I can go on and on. Mo 3, etc. Who's killing these rappers? Their own. Crips and Bloods wars. I can't wear blue, I can't wear red. You gonna kill me because of a color? Right? Set tripping. It's our own. Who named us African Americans? Jesse Jackson. I was watching a video called Into the Light, I think it's called. It's a Malcolm X documentary. And one brother was on there saying that his mother told him, or would teach the children, that it's not okay to call yourself Negroes. Don't call yourself Negroes. That's not good. We're not Negroes. We are Black people, and we should be proud of being Black. When I saw that, I was like, you know, Negro and Black is the same damn thing. One is in Spanish and the other one is in English. What are you talking about? You see the ignorance. But why does that ignorance exist? It exists because of our own people leading us down the wrong path. Who else is guilty of these things? I don't know. Alex Haley with the whole roots thing, making us believe that we came from Africa, right? Et cetera, et cetera, et cetera. Farrakhan, Al Sharpton, Clef Dollar. TD Jakes. What's his name? Sweet Daddy Grace. If you're not familiar with Sweet Daddy Grace, he was the guy who established the International House of Prayer.
Elijah,
Look at him. Huh? What was that?
Elijah Muhammad.
Elijah Muhammad. Now let me get this right. So you were once Elijah Poole Bay. You studied under the prophet, which means then you know about the bays and the ills, Day, Ali, and Al, the Fez, the turbans, the Moroccan or the Moorish nationality. The good prophet was assassinated. You go off to establish the Nation of Islam. And instead of having the brothers wearing fezes, you got them wearing bow ties. Instead of calling them Asiatic, you calling them Asiatic black man and black Muslims. Instead of telling them that they're bays and ales, you giving them that you're saying that, oh no, your name is unknown, your ex. Egregious. So what happened? Notice the difference with Malcolm. Malcolm was taught hate. Who taught him hate? Elijah Muhammad and the Nation of Islam. The white man is the devil. The white man is the devil. So in that same documentary, you see two different Malcolms. You see the first Malcolm, which is the belligerent Malcolm, the angry Malcolm, the Malcolm with the wrong energy. The white man, the white man, the white man, the white man. Blue-eyed devil, white man, it makes me cringe in hindsight. Keeping in mind that I used to love that Malcolm. But when I came across Prophet Noble Ali, I learned about love instead of hate. When I came across international law and diplomacy, I'm seeing things differently. Well, what happened with Malcolm? Well, he went on to the pilgrimage in Mecca, met with other people, other international, should I say other nationals of other states, learned something. What did he learn? I don't know. When he came back, he started using the Il Hajj Malik El Shabazz. Oh, I wonder where that came from. And then he started saying his entire attitude and way of being totally changed. It's no longer the white man this and the white man that. Now he's talking nationhood and United Nations. Well, he learned about Prophet Noble Ali, what was being hidden from him. Now, there's this thing called the supreme wisdom in the Nation of Islam, in which you're supposedly is when you learn about being a Moor and all that. But why do I have to go into some special degree before I learn this? Prophet Noble Ali didn't do that. From the very beginning, he taught you was a Moor. And from the very beginning, he taught you that you were supposed to be wearing your fez and your turban. And from the very beginning, he taught you about your bay and your ill. Now, he also had the adab chamber, which was for additional degrees. What degrees? More than likely, civics. More than likely, international law information. But we know that's been circumvented. We know that's been infiltrated. We know that's been corrupted. Because I can assure you right now, the adab chamber is not the same adab chamber of the years between 1913 and 1928. Anything past 1929 after his assassination is absolutely corrupt. How do we know that? Well, there was a three-way split. We all know that. Everybody knows that the temple is compromised and no one has cleaned up the temples. It's ugly. But you're right about Elijah Muhammad, amongst others. There's so many of them out there. Elijah Muhammad, Sweet Daddy Grace, Fard Muhammad, and I forgot the other guy. They all ran in the same circles. They all went to the Adams. They all were part of the temple. They all were in the Adams chamber. When the prophet passed away or was assassinated, they all went off and did their own thing and just changed the entire narrative that the prophet was teaching.
Oh yeah, Father Cherry.
Who?
Father Cherry, if I'm not mistaken.
I'm not sure who that is. Who's Brother Terry?
Cherry, Cherry, if I'm not mistaken. That was Daddy Grace, Father Cherry,
yeah.
Who and CM Bay came out on top of all of them.
Yeah, and CM Bay as well. Yep. CM Bay was the righteous one.
Yes,
Islam. I thought it was also Father Divine.
That's correct.
yes.
Yeah.
No, not Father I think. Wait, hold on. Father Divine isn't Father Divine.
It sounds familiar. Sounds familiar.
Yeah, Father Divine. You can look it up. You can Google it.
Daddy Grace, Father Divine, Father Cherry, Elijah Poole. But CM Bay is the only one that saw the vision and took it to a direction.
That's correct. I thought Father, if I'm correct, I guess I'm wrong. Clarence 13X. Is that not Father? No, that's Father Allah.
Yeah, he came later.
Yeah, he came later. Yeah, so Father Divine is someone else. Okay, yeah. So Father Divine, I think you're right about that one. Yeah, yeah. Clarence 13X. He's the brother with the he was
5%ers.
5%ers. Yeah, he was kicked out of the Nation of Islam and he established the 5% nation, Gaza and Earths, which they used the circle 7 as their symbol.
Mm-hmm.
You know, the prophet is the foundation to it all. Period.
Yeah, the dude Reverend Ike came up under Father Divine.
Exactly. Right. Yep. Reverend Ike. Yep. That's another one.
Wow.
Yep.
Yep.
Yep. Reverend Ike.
And can't lose with the stuff I use. My mom used to watch him, man. I was a little boy.
And they all chased that money. They all chased that almighty Federal Reserve note.
Yes.
That's correct.
My mom gave so many donations for that little piece of red cloth. Man, I'll never forget it.
The prayer cross.
Yep.
Yep. Yep. You see how they did us? You see how many names we mentioned of those who look just like us, who even ran with the prophet, and look what they did. Look what they did. So if the white man is the devil, then what does that make them?
The black devil. Let me stop.
No, you're absolutely correct. That's the answer to the question. Which is a more formidable, which is a much more formidable devil, because we taught them everything anyway.
Mm-hmm.
Let me tell you something. In my personal experiences, I've had great experiences with Albayans in my personal experiences. And when I'm talking about the low level, the regular everyday people than I have with my own. I get more problems from my own than so-called white people. For example, when I watch, I own a pressure washing business. I pressure wash houses and stuff. When I go to a black man's house or a black woman's house, they're always trying to haggle me on the price that I'm charging them. I always want to talk me down. I always want something for free. I always want something for less. When I go to the white man's house, when I give them my price, they don't even budge. They're like, okay, just, good. Let's go for it. I had this one Albayan lady. I told her like $350 for a job. She told me, okay, well, that's good. 400. I got you. I'm like, what? I said 350 in the back of my head. I'm like, I thought I said 350. She added an extra 50 to this.
Yep.
I've always had great experiences with white people. Don't get me wrong. I've had bad experiences here and there, but the overwhelming amount of bad experiences I get from my own people. I knocked on someone's door, left a flyer. She called me, telling me, just cussing me out, saying that I left the flyer, and that's why I'm glad I got a camera for people like you. I'm like, no, you got a camera for people that's trying to break in and rob your house, not for someone who's trying to earn an earnest dollar by knocking on your door and left a flyer. Are you serious right now? Are you really serious? She called the police on me. Talking about this is a no soliciting neighborhood. Well, I said, well, the sign on the front of the neighborhood was not big enough. I didn't see it. What you should do probably is, here's an idea, put a no soliciting sign on your door.
Mm-hmm.
Because if you did do that, I never knock on a door that says no soliciting.
All right.
But you didn't have one at your door. So to me, you're open game. But for you to come at me like that from earning an honest living, my intent could have been to break in your house. Instead, I'm trying to earn an honest dollar, and this is how you coming at me. It's all, so it's like the black man is the new white man or something. It's crazy.
Let me interject right there. You made a great point. Uh, the best thing that I can say in regards to that statement you just made, Moors, everyone should study over and over and over. I've had my 101s of Drew Ali since 94. It's only been in the last maybe year, 2022, 2021, have I begun to really comprehend on a higher level, on a seventh level of what the 101s entail. The higher self and the lower self, those are major issues. We, you, I, we all have to recognize, become able to recognize when the higher self is speaking and when the higher self has stepped off the throne and the lower self, Satan, devil, dragon, and beast, steps on the throne. And when we're able to make that discernment, you you know when to walk away and just smile and say, oh, they're talking from the lower self, talking out the side of their neck, and keep it going. Otherwise, anxiety, anything of the lower self, I'll put it that way. Drew Ali says, the higher self, et cetera, et cetera. The lower self breeds lewdness, murders, theft, and everything that harms. So it's a 101 thing always, even with you, the higher self, with your lower self. I yield the floor.
You're absolutely correct. You must slay the dragon. What dragon? The lower self.
Mm-hmm.
And your higher self must take over. And so what we witnessed with the AMPAG unfortunate drama, what you were witnessing was the lower self in operation. That's the lower self. Keeping in mind that a lot of it deals with envy and ego. Envy of what? Envy of J. Jermaine Bay. Why? Because J. Jermaine Bay has galvanized quite a few people, including the people of the state. They respect him. They look up to him for good reasons. When you're a teacher, people tend to, gravitate to you and follow you. You're teaching. You're in a position of you're in a leadership position. Some people just deal with ego and jealousy and envy. The lower self, right? Ego is not necessarily bad. It's just how it's being used. From what perspective are you coming from with your ego? Is it the lower self or the higher self? The higher self aspect of your ego is for your protection. But the lower self aspect of your ego is for your destruction. Anything dealing with the lower self is dealing with your destruction. It's imperative that we ascend to the higher self, right? That's turning water to wine. Water is the lower self, wine is the higher self. That's what Jesus was talking about. An inner transmutation, an inner alchemy, transforming yourself from the lower self to the higher self, shedding the negativity and bring forth the positive natures of your inner being, i.e. the higher self. Islam. This was an excellent discussion. And as always so, when the good brother Floyd is on.
I can't do it without you. I can't do it without you, Moore.
But I can't forget Sister Makara. And of course, I can't forget my nationals and everyone else all the other guests and everyone else who show up. I appreciate it. I thank you. I'm grateful for it. This was an excellent discussion. But I guess it's time now to shut it down. And we done went on a little longer than I wanted it to. It's 11:30 now. I mean, I can go on, but got to get up in the morning, right? Get to work. And everyone else does as well. So I just to close out, just want to say, we need our states. That's why we're going over this treaty real quick, or not real quick, but that's why we're going over this treaty, because it teaches us that it's all about states. International law deals with states. And the one thing that we've always been missing is our state, which if you don't have a state, then you don't have unity anyway. And then you don't have protections as well, which is more important. Well, both of them are equally important, unity and protection. You gain your protection from your unity. First, you need the unity, then you gain your protection. You know, imagine if all Black people, so-called Black people, were absolutely unified. Imagine if all Black people would boycott Adidas for what they did to Ye. Do you know how much power we have? We account for like trillions of dollars as consumers, man. We are the ones who's making all these companies rich. Imagine if we boycott these companies and we can single-handedly shut down the entire system if we just simply don't participate in their system. We ain't even got established governments. We just had to just cease all our participation. What if everybody decided to not go to work, not pay no bills, not buy nothing for 30 days? Imagine what could happen. We have all the powers. There was a white lady, a non-Bayan lady on TikTok that was saying this. Black people, you guys just don't know how powerful you are. All the power lies in your hands. I don't know if you all seen that. I shared it in a Telegram with our state, but she made a great point. You know, granted, she was talking towards the end of the video, it turned into voting, which we also have the power in that, but that's not where we want to be. If we want to exercise our power to vote, we need to do that within our own state. But aside from voting, we have the power just by simply boycotting everybody. You treat one of us a certain way. Imagine if everybody stopped watching the NBA and stopped showing up to the NBA games because of what they did to Kyrie Irving. This is what's called unity. You persecute and do one of us wrong. That means then that we all jump on you, and not jump on you, you know, violently, just basically boycotting, doing things of that nature. But we ain't gonna do that. Why? Because we love our Gucci, we love our Jordans, we love our Adidas, you know what I mean? We're just materialistic and just messed up in the head. Why? Because we're confused. We don't even know who we are. And the people who don't know who they are, see, when you talk about the lost tribes of Israel, we are the lost tribes. We lost. Wandering around the desert for 40 years, trying to find home, just like Dorothy. Not even realizing that all we have to do is click our heels 3 times and we go back home. What are those 3 clicks? Sovereignty and independence, integrity of domains, economic liberty without any inequality. What's the other 3 points? The judicial branch, executive branch, and legislative branch. The 3 points of light. What kind of shoes was she wearing? What color shoes was she wearing? Red? What does that represent? The cherry tree that George Washington chopped down? What cherry tree? The Moorish flag, the red flag with the 5-pointed green star in the center, love, truth, peace, freedom, and justice. So we have to come into the mindset of Luke Skywalker when he beheaded Darth Vader. We have to come to the mindset of Neo in the Matrix when he jumped inside of Agent Smith. Our powers are unlimited. The only ones who are placing limits on our power is our own. We are the ones who are placing limits on our power, no one else. They're so scared of us, they keep killing us through the police and all this other stuff. Misinformation, miseducation. They're trying to project their fear on us, and it's been working. Not only are they projecting their fear on us, but our own leaders are projecting fear on us. Fear and hatred. What kind of fear? Fear of the white man. What kind of hatred? Hatred for the white man. The only people that would remain in a state of fear like that and hate are those who feel powerless. And that's the problem. We feel powerless. Why do we feel powerless? Because we don't know who we are. If we knew that we were Moroccans and we knew that Moroccan law is the supreme law of planet Earth, really, and that all we had to do was enact our government, establish our government to then enact legislation, fear and hate would dissipate. Now, if there's no more fear and hate, then what's the opposite of that? What would emerge? Courage and love. We got to recognize that they're just Albayans who are actually afraid of us, actually. And what's their fear based in? Their fear is based in the fact that they know what they have done. And if we come to the knowledge, what is it that we would do? What WWJD? Y'all remember those bracelets back in the day? WWJD. What does that stand for? Do y'all remember those bracelets? I'll remind you. WWJD was, what will Jesus do? I don't know if y'all remember those bracelets, but people used to be wearing those bracelets all over the place. That was a thing at a point back in, like, I don't know, 10, 15 years, 15, 20 years ago.
Yeah, I remember.
You remember that? What will Jesus do? Keeping in mind that Jesus is what? Brother Floyd, you know this answer. What is Jesus?
Jesus is justice.
Jesus is justice. What will these Moors do when they wake up and realize that we lied to them? That's the fear, because they know our history. They know who we are. If we're so violent with ourselves, imagine how violent we will be with them once we find out the truth. We'd be done burn this whole thing down. This is where Moors come in, because we had a prophet that taught us to love instead of hate. And when you're in the spirit of love instead of hate, you're willing to negotiate and deal with diplomatic relations. Like the treaty said, friendly relations and cooperation amongst nations. And so us at AMPAG, New Mecca, and Meru, we're no longer in a state of fear, or we're definitely not in a state of hate. We're in a state of courage and love. Why is that? Because we recognize that our laws are, in fact, the ultimate authority. And all we got to do is check the boxes and exercise such power, such authority. Islam, with that I yield, or I close, actually, I should say.
Islam.
I think, go ahead, you had something to say, brother?
No, Islam. Just saying Islam. It's been a great class.
Islam, I appreciate that, good brother. Gratitude to you and all the attendees and all those at home who's watching. And to you all, I'd like to say, may the blessings of Allah be upon you all. Peace, love, and prosperity. Islam.
Islam.
Faith.
So
Islam.